This is Democracy Watch. So, Mark, this might seem a little wonky here, but the implications of what just happened are pretty massive. So, the Eighth Circuit Court of Appeals has refused to reconsider its earlier decision that private parties and voters can't sue to enforce Section 2 of the Voting Rights Act. So, what does it mean for the states that are under the Eighth Circuit?
Yeah. So first of all, you're right. It's wonky, but it's very, very important. And I think it's a lesson that people need to keep in mind that oftentimes things that look very internal or processy can have enormous consequences on the lives of everyday Americans when it comes to participating in democracy. So there are seven states in the Eighth Circuit: Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. And what it means is if you're in one of those states right now, you can no longer bring a lawsuit to enforce Section 2 of the Voting Rights Act. We have talked about Section 2 of the Voting Rights Act as the key that has allowed Black voters to gain additional congressional districts in Louisiana and in Alabama. My team won cases there. We won cases in Georgia. This is a critical part of what makes American democracy work. And in those states now, those seven states, private citizens and groups can no longer bring those cases. Only the Department of Justice can, and the Department of Justice doesn't have the resources to be bringing every Section 2 case to protect all the voters in the country.
Okay, now looking forward, if we game this out, so right now, to your earlier point, if you are if you live in a state that's under the jurisdiction of the Eighth Circuit, you can no longer bring these cases if you're a private party. Only the DOJ can bring these cases, and we'll speak about that in a moment about the limited resources of the DOJ. But let's say the plaintiffs in this case appeal to the U.S. Supreme Court, and the U.S. Supreme Court sides with the Eighth Circuit. Then would it become a national standard that no private parties can sue to enforce Section 2 of the Voting Rights Act?
Yes, and this is what the conservatives want, right? The conservatives want there to be what's called a circuit split. When some circuits rule one way on federal law and some circuits rule another way on federal law, that is one of the most common reasons why the Supreme Court hears a case, right? Supreme Court only hears 60 to 70 cases a year. There are millions of cases filed around the country. Thousands and thousands of them through the courts of appeals try to get to the U.S. Supreme Court. One of the reasons why the Supreme Court takes these cases is because there's a disagreement between circuits. And so conservatives have been floating this idea that there's no private right of action in all of these different circuits. They got one to bite in the Eighth Circuit, and their goal is to bring this to the U.S. Supreme Court because, let's be honest, the Eighth Circuit is important, but when you talk about voting rights and Section 2 of the VRA, you start looking at the Fifth Circuit, the 11th Circuit with Alabama, Louisiana, Georgia, Florida, the Deep South. And so what they want to do, what the conservatives want to do is use this circuit split as a way to either get the Eighth Circuit case up there or one of these other circuit cases that's gone the other way so that the Supreme Court can rule on this with a 6-3 majority. They are hoping the Supreme Court will strike down private rights of action in a nationwide basis, and that would be crippling to Section 2 of the Voting Rights Act.
Well, here's the thing, like, the only people who could appeal this are the losers, and that would be the people like the pro-democracy faction. And so wouldn't it be in our best interest now not to appeal to the U.S. Supreme Court, knowing that we risk this being a national standard?
Look, that's probably right. I'm not going to tell the people who brought this case what they should do or shouldn't do, but there's definitely an argument there. But understand that there are other cases in other circuits where the courts have said there is a private right of action. And the fear is that in those cases where the conservatives have lost, that they may now go to the U.S. Supreme Court and say, Supreme Court, we may have lost in the Fifth Circuit, 11th Circuit, but look at the Eighth Circuit and there's a split, and therefore we think you should take this case. So even if the pro-voting groups don't bring this case in the Eighth Circuit, it's no guarantee that where conservatives lose somewhere else, they won't use it as an opportunity.
Well, no, the Supreme Court itself has already upheld Section 2 of the Voting Rights Act in a number of states, in Louisiana, which we've spoken about at length, in Alabama, which we've spoken about at length. I mean, this is a provision that they uphold over and over again. So would that lend itself to this idea that if it was appealed, that they would rule against the Eighth Circuit?
Yeah, look, this is a point that's been made on Democracy Docket in piece after piece, in case page after case page there, that the Supreme Court hasn't just upheld Section 2 of the Voting Rights Act recently. I mean, they've been upholding Section 2 of the Voting Rights Act since it was enacted in 1965. All of the cases we've been talking about for the last 2 years, and by the way, all those cases that go back, 20, 30 years, these are all cases brought by private parties. The vast majority of the cases that are brought by under Section 2 of the Voting Rights Act are brought by private parties. And the Supreme Court has never, back then or most recently, ever said boo about there not being a private right of action. But the concern is that, all of it, we saw this with Dobbs. We've seen this in other cases, that all of a sudden a conservative majority of the Supreme Court wakes up and says, oh, wait, we never thought about that before.
Yeah. Well, by the way, for anybody watching right now, if you want to stay on top of what's happening here, you can do so by subscribing to Democracy Docket. It's the free news outlet Marc founded to focus on everything voting in elections. I'll put the link right here on the screen and also in the post description of this video. It's a great resource, is what I use to find out any information that I need about all of this stuff. Marc, going back to the Eighth Circuit, now that only the DOJ can sue to enforce the Voting Rights Act within the states under the Eighth Circuit, is it prepared to do that? Like, does the DOJ have the resources?
No, and there are some remarkable statistics about this. I mean, the truth is that if you look at the number of cases that the Department of Justice brings to enforce Section 2 of the Voting Rights Act, it is a fraction. I mean, it is in the single digits compared to the number of cases brought by private parties. The people think that the Department of Justice has unlimited resources, but the voting section of the Department of Justice does not have unlimited resources, and they have to cover a lot of ground. They have to not just cover Section 2 of the Voting Rights Act, they have language provisions they have to enforce, they have to enforce other constitutional provisions, and of course, Republican states are doing more and more bad things and stretching those resources further and further.
Right.
So virtually every case you and I have talked about in the last 2 years involving voting and the Voting Rights Act, whether it is Louisiana and Alabama with Section 2 of the Voting Rights Act, whether it is the victories that we just saw in Wisconsin or in North Carolina, these were all brought by private plaintiffs. These were not brought by the Department of Justice, and it has been a absolute tenet of the conservative movement, the Leonard Leo groups, and the Republican Party in the last 4 or 5 years to try to stop private litigants from suing, because I'm able to bring litigation on behalf of organizations in a multitude more cases. I mean, right now my team is litigating more than 40 cases in more than 17 states.
Yeah.
That's just the level of activity and resources that the Department of Justice can't bring to bear. So every time the right wing can shut down private litigants, either by taking away Section 2, by curtailing a constitutional doctrine, by promoting the now disgraced and rejected independent state legislature theory, all of these are efforts to shut down to block the courthouse doors so that everyday Americans don't have their voting rights enforced.
Is it possible for the Attorney General to beef up the DOJ? Is it possible for Democrats, if they control the purse in Congress and they're in the majority, to allocate more funding to the DOJ so that they can take care of this in the future if this does become an issue in the Eighth Circuit, or if it becomes, God forbid, a national standard?
Absolutely. Look, and there is no question that I think that Department of Justice needs more resources put behind it, and they need to prioritize these voting cases. I mean, Ron Klain, the former White House Chief of Staff, after he left, said that he was disappointed at the pace of cases being brought by the Department of Justice. DOJ needs to allocate more resources. Congress needs to give them more resources. We need to pass the Freedom to Vote Act and the John R. Lewis Voting Rights Advancement Act, because those would give more tools both to Department of Justice and private litigants. But even if we did all of that, Brian, even if all of that happened, we are still not going to cover all of the ground. And of course, there are going to be times when Republicans control the Department of Justice and they won't prioritize it. So we cannot take away the tools that private litigants and lawyers use to protect the right to vote and free and fair elections, because that's what Donald Trump wants. And it will be a really, really sad day in America if the Supreme Court goes along with it.
What happens to the Section 2 cases that are currently pending in Eighth Circuit states?
Well, so look, if there are cases brought by private litigants, they right now are in real peril because the Eighth Circuit has said there's no private right of action. There may be some new legal theories. My team is looking at different legal theories about how to, how to deploy other federal laws that may re-empower Section 2 or Section 2 like claims. But for right now, it is a bad thing to have a Section 2 claim and a private litigant in those 7 states.
And let's finish off with this. How do we recover in those states? Like, is this, I mean, I understand that if we don't, that this is final because it's a circuit court, and the only way that it can be overturned is if it gets appealed to the U.S. Supreme Court. And then, of course, we run the risk of them ruling in the Eighth Circuit's favor and it becoming a national standard. And so logic would suggest that they don't do that. They don't appeal to the U.S. Supreme Court. But then in those states, is that it for Section 2 of the Voting Rights Act? Is there any way to get this back, to recover the ability to ever enforce Section 2 of the Voting Rights Act again?
So here's what I'd say to that, and here's what I'd say to Republicans, because they're always trying to cut off access to the courts and access to protecting voting rights. My team is looking at what alternatives there are in the Eighth Circuit, what alternatives there may be nationally if this were to come to pass. We are not going to give up. We are going to be dogged. We are going to continue to find ways to bring claims to protect voting rights. And I hope they include Section 2 claims. I hope that that Section 2 is not foreclosed in the Eighth Circuit or anywhere else in the long term. But until the Supreme Court rules, it is going to be foreclosed in the Eighth Circuit under current jurisprudence. But again, courts change, new legal theories develop. So if you are in one of those 7 states, if you live right now in Nebraska or South Dakota, or in North Dakota or Minnesota or Missouri or Arkansas and Iowa, don't give up hope. They want you to give up hope. Know that there are people out there fighting and trying to figure out how to protect your voting.
Well, we'll leave it there. Obviously, I speak, I think, for everybody watching right now in expressing how grateful we are for the work that you and your team are doing. I mean, this is the battlefield for voting rights right now. So again, a small lift for all of us, but the small step that we can take to show our appreciation for Marc and his team, again, is to sign up for Democracy Docket. The link is right here on the screen. It's also in the post description of this video. I'm Brian Tyler Cohen.
I'm Marc Elias.
This is Democracy Watch.